Hi, everyone, and welcome to today's webinar. My name is Jason Q. I'm the Managing Attorney for Nonprofit and Small Business Legal Assistance Programs at the DC Bar Pro Bono Center. Welcome to today's webinar, Developing Better Bylaws, Supporting Mission, Governance, and Operations at Your Nonprofit. Before we start, a few logistical notes. First of all, if you look in the GoToWebinar dashboard, you'll see a drop-down option for handouts. If you open up that menu, you can download a copy of today's PowerPoint slides and also a copy of our template bylaws. These are sort of generic bylaws that we provide folks, especially folks who are looking to start a nonprofit. I've screenshotted in a lot of these provisions into today's presentation. So you don't need that document to actually follow along with today's presentation, but I figured you might be interested in having it on you. For folks who are listening to this webinar after the fact, there is a link in the final slide of the presentation for you to go and download that template bylaws. There's also a questions function on GoToWebinar. So during the presentation, if you have a question, type it in. I will check questions periodically, probably mostly towards the end, just because we have a lot of material and I want to make sure that we're staying on time. But I will try my best to get to your questions. If I don't get to your question during the presentation, my email address is on the last slide. You can email out and we can chat offline. Okay, great. So before we start, let me tell you a little bit more about us here at the Pro Bono Center. We are a legal services organization and we match nonprofits through our nonprofit legal, let's start again. We match nonprofits with pro bono legal counsel through our nonprofit legal assistance program. Through this match program, pro bono attorneys can help with many different types of legal matters, including governance, IRS compliance, employment law, and real estate matters. If after today's presentation, you feel like you need a total overhaul of your bylaws, that is a service that we can provide. We can look at your bylaws and your other governance documents as part of that match program. We also host in-person and online legal clinics to address specific issues, including governance, but also other issues like risk management and intellectual property. We sponsor trainings, webinars, and podcasts on important real-world legal issues facing nonprofits, and we provide written resources and our archived webinar library on our resource website, and that website is www.probono.center/nonprofits. Okay, so today's presentation is going to be in two large sections. We're going to start with an introductory section where we're going to talk about the functions, purposes, and goals of nonprofit bylaws generally. And then we'll move into anatomy of nonprofit bylaws, where we'll kind of go from top to bottom through that template bylaws. And I'll point out specific sections and issues that you might want to be aware of and that you might want to think about at your own nonprofit. So that'll be more of a sort of issue spotting exercise. But let's start by kind of zooming out a little bit more and talk about what role your bylaws should be playing in your nonprofit organization. So we'll start with some governance 101. Most nonprofit organizations are corporations that are governed by a board of directors. That is 99% of nonprofits. The board, in turn, is structured, empowered, and regulated by the articles of incorporation, the bylaws, and relevant governmental legal authorities. Your articles and your bylaws are your governance documents or your organizational documents. The articles are like the constitution for your nonprofit. They set forth broad principles for how it'll operate. For example, it'll say that your nonprofit will only be operated for the benefit of the public, that you will abide by 501c3 rules and regulations, and that you will have certain governance structures that are kind of fundamental to the way that your nonprofit is set up. The bylaws are a little bit more specific. They're more like statutes. They have rules that govern the general operations of the nonprofit and that are consistent with the kind of broader principles that are set forth in your articles. So your articles might say the nonprofit will have a board of directors. The bylaws will say the board shall consist of between 3 to 15 directors. So it drills down a little bit further. Let me just click in here. Someone's asking if they'll receive a copy of the presentation. As I mentioned, there is a handouts tab here on the GoToWebinar platform that you can use to download a copy of today's presentation. Okay, So how are bylaws created? So the bylaws are initially adopted by the very first board of directors right after the nonprofit incorporates. They can then be amended by subsequent boards. Bylaws may contain any provision for managing the activities and regulating the affairs of the nonprofit that is not inconsistent with the articles or existing laws. But as we'll get into, there is sort of a logic and a reasoning for keeping your bylaws concise and manageable, and not trying to fit everything possible into your bylaws. You can do a lot of policy setting and rule making in governance policies and in board manuals and in other documents that aren't in your bylaws. So that's something we'll explore today, is what belongs in your bylaws and what belongs outside. Okay. The DC Nonprofit Code does contain a lot of default provisions that apply in cases where the bylaws are silent on key issues. For example, can the board hold a meeting via conference call? If your bylaws don't speak to that issue, the DC Code says by default, yes. So for clarity and consistency though, it's still best to address and include these kind of code covered legal requirements in your own bylaws. No one wants to sort of memorize the nonprofit code. So when we go through our template bylaws, when we go through our anatomy of bylaws, you'll see that a lot of what we're covering is stuff that's also covered in the DC code. It's because we want to import those requirements into our own bylaws, and where we have flexibility to deviate from the code, we want the opportunity to do that and to make that decision ourselves. Just for illustrative purposes, here's sort of the index of the DC Nonprofit Code to just show you the scope of it. This is interesting only to lawyers, but you'll see there in section 5, we have a lot of membership provisions. In section 6, that's where we talk a lot about officers and directors of nonprofits and the rules around those. So you'll see, subchapter 8 is about amending your articles and bylaws, providing default rules for doing that. So you'll see there's a lot covered in the code. Okay, so why are bylaws important? Well, here are some key reasons. First and foremost, they define the process for authorizing actions and decisions of the board. They define the who, what, where, why, and how regarding how the nonprofit will make major corporate decisions. Decision makers, so that's the board of directors, and also your corporate officers, they get their legal authority to act via the bylaws and must act in accordance with what the bylaws stipulate. A second big function of the bylaws is establishing your overall governance structure. Bylaws create or implement governance structures, so for example, your board and your board committees, that then affect the organization's day-to-day operations. A third big function is that they set individual responsibilities. Bylaws frame the function, roles, and responsibilities of key personnel, including your members, if you have them, your board of directors, your officers, and your key personnel. And we'll go through who some of these people are later in the presentation. And finally, your bylaws are legally enforceable. They are essentially a contract between the nonprofit and its members, if you have them, its directors, officers, and its key personnel. A breach of the bylaws can cause legal liability for the organization as a whole and to those breaching individuals for any damages or other harm that's caused by the breach. Enforcement can come in the form of a court action, maybe a lawsuit that's filed by the non-breaching directors, or by regulatory authorities like the IRS, or here in DC, we have the DC Office of the Attorney General. Okay, great. So when we're developing bylaws, we have 6 key goals or themes, and I'm gonna come back to these throughout today's webinar. So I wanted to lay them out kind of upfront. The first kind of big goal is to ensure legal compliance. Your bylaws are themselves required to apply for and obtain and maintain your federal 501c3 nonprofit status. But more kind of importantly, the bylaws themselves codify structures, responsibilities, and practices that are needed to satisfy other relevant legal requirements. And these legal requirements can stem from the DC Nonprofit Code, which we've already covered, which has specific requirements about your board composition, your meeting procedures, your other procedures, and also rules around officers and members, and also indemnification, which we'll talk about later. We also want to be concerned about the IRS. The IRS has general rules and regulations regarding your nonprofit's mission and purposes and the requirements for maintaining your 501c3 status. And then finally, there are fiduciary duties of nonprofit directors. So directors and officers of a nonprofit have legally recognized and enforceable duties of care, loyalty, obedience, and a duty to inform. These are sort of standards of conduct that directors have to follow while they're discharging their responsibilities and serving in their role. So bylaws create the infrastructure for satisfying and exercising those duties. Bylaws say you have to hold meetings, you have to or can have committees, and these are the environments in which the directors kind of discharge and exercise and fulfill their fiduciary duties. It's also a mutually enforcing system because that third duty, the duty of obedience, requires that directors adhere to the articles of incorporation and the bylaws and any other legal authorities that affect a nonprofit. So, complying with the bylaws is itself part of your fiduciary duties. Two sides of the same coin. Okay, that's goal number one. Goal number two is developing bylaws that maintain consistency internally at your organization. So, our former assistant director, Regina Hopkins, had a golden rule: bylaws should say what you do and you should do what they say. I really like that rule. That means that your bylaws should be consistent with the actual practices of your organization. If they're not, you can call into question the legality of your organization's actions if they're not properly authorized and executed in accordance with your bylaw requirements. So I have some tips and next steps in this section for consistency. Review your bylaws for requirements that might be out of step with how your organization actually operates today. Then decide for those inconsistent provisions. Do we want to revise the bylaws, and keeping in mind that there are some legal requirements, so we have to make sure that we're able to, or two, should we change our current practices to comply with the bylaws? So part of your sort of bylaws audit analysis that you might want to do after this presentation, look for those inconsistencies in practice. Another realm of consistency is consistency between your bylaws and other key organizational documents. And here, I'm specifically concerned about your articles of incorporation, other organizational policies that you might have adopted, like a conflict of interest policy, and your annual Form 990 filings to the IRS, where you provide a lot of information that overlaps with what should be in your bylaws and your articles. So inconsistencies between these documents can be small or technical. Maybe you don't consistently use the term president versus the term chair to describe who the head of your board is in those documents. That's a pretty easy fix, but they can also be major. For example, maybe your mission or purposes is articulated differently in your articles and your bylaws and your 990 filings. And I see this a lot. Because you file your 990 every year, when people put in their mission description in their 990, it can be a little bit more up to date. It could be something that's evolving, and that might end up being out of sync with what's in your bylaws, which are amended much less regularly, and definitely your articles, which are amended even less regularly than the bylaws. So another next step is to ensure that the mission, your description of key programs, description of your basic governance structure, etc., are consistent across all of your organizational documents and government filings. Start by conforming with your articles, because again, your articles are the constitution of your organization, or amending the articles if necessary, if you need to amend the articles to make them consistent with current practice. And then after you've got your articles set in place, conform your bylaws and your other documents and your filings accordingly. So a third goal for our bylaws is to have clarity in the language and the requirements contained within. The language in your bylaws should be clear and unambiguous. You should be concise and avoid unnecessary legal jargon that might cause confusion. Ambiguity in your bylaws can lead to conflicts of interpretation and implementation amongst your board of directors and other key stakeholders. Conversely, clear language can prevent or resolve conflicting understandings of how the nonprofit is operated and governed. So the next step here is to go through your bylaws generally and identify clauses or provisions that are open to multiple interpretations or that have caused confusion in the past. Discuss and revise those provisions using clearer, more unambiguous language. Pretty straightforward. Number 4, completeness. Bylaws should address both regular recurring situations like how you're going to hold your annual board elections, but also address rarer kind of what if or worst case scenarios. Examples include creating a process for removing directors or a process for approving the dissolution of your nonprofit. It's important to address these awkward, sensitive issues head on because it saves you conflict down the road. For example, we're going to talk later about a potential attendance requirement for your nonprofit directors. Having an automatic attendance requirement that removes directors if they don't show up to meetings saves you from having the awkward conversation of saying, oh, your attendance isn't up to scratch. You know, I've made this sort of subjective determination that you're not doing your job. Instead, you can just go, you know, the bylaws say you have to come to X number of meetings. You haven't. Sorry, you're out. Again, the DC Nonprofit Code does have default provisions that fill in a lot of these holes. So if you are silent about an issue, there's a backup, but we don't want to rely on the code. We want the bylaws themselves to be complete and to contemplate issues that might face the nonprofit. Our fifth goal, and this is maybe one of the biggest ones, is to ensure flexibility. Bylaws should give nonprofit leaders maximum flexibility to deal with changed circumstances and/or pressing needs. For example, even if you prefer having in-person meetings, your bylaws should allow the board to have telephonic or web meetings in case that situation arises. And that's obviously at the top of my mind because at the beginning of the COVID pandemic and quarantine, a lot of nonprofits had to shift immediately to having electronic meetings. And some organizations found out that in their bylaws, they were not allowed to have electronic meetings. The bylaws only had language allowing for in-person meetings. So that is an area where flexibility, planning for flexibility on the front end would have saved them some headaches down the road. Bylaws should create a floor, not an ideal or best practice version of your governance and operations. You can operate your nonprofit in a much more strict manner in practice, but bylaws should create kind of a range of practices to account for situations that might be challenging or difficult. So use ranges when appropriate, like the board shall consist of between 7 to 15 directors, and give the board general authority to create non-essential officers and committees rather than locking yourself into a rigid committee structure or officer mix. So one example might be, you know, it's a really good idea for some nonprofits to have a program-focused advisory committee that involves members of the community and you get community insight. Really good practice. But you have to recruit members of that committee. You have to, you know, in a situation like the COVID pandemic, maybe that committee falls apart or can't meet anymore. If your bylaws say that you have to have that committee, it has to always be operating. It doesn't have the flexibility to account for kind of a challenging or emergency circumstance. So you'll see that theme come up again and again. We're going to use the bylaws to have kind of aspirational goals and to create a structure for operating at a nonprofit's full capacity, but we also want to be able to contemplate situations where we might not be able to do that. Also, not everything needs to be in your bylaws. A lot of follow-on policies create more detailed requirements and procedures, but can be amended much more easily. And we'll touch on that near the end of the presentation. Finally, a final goal of your developing or amending your bylaws is to establish your culture and your values. So the contents of your bylaws will affect how your organization is run and overseen, which will in turn affect your organization's broader culture and codify its core values. So aside from the sort of the obvious provisions like your mission or purpose statement, consider how the contents of your bylaws affect your nonprofit's posture towards collaborative or participatory decision-making. That's one key area. Your bylaws will affect the balance of power between the board, your members, your officers, and staff. So issues in your bylaws, like the existence of an executive committee or the existence of standing non-board committees, or the scope of the executive director's role, whether the executive director is also a director on the board, whether some decisions require a supermajority vote. These all affect kind of the balance of power within your organization. Another area that I wanted to highlight is your board culture. So there are issues in your bylaws like the term limits on your board, attendance requirements, what it takes to remove a board member. These all communicate expectations about board service and the general culture of your board. And then another area that's very relevant, especially given recent events, is a focus on diversity, equity, and inclusion. Are there binding and/or aspirational commitments to advancing DEI in your bylaws? Is there a process or at least an aspiration for recruiting a diverse, inclusive, representative board? This is something that I think we're going to see more of at the governance document level. You can have a separate policy around diversity and inclusion, but I'm seeing some nonprofits now having an interest in putting right up in their bylaws some sort of statement or commitment, committing themselves to advancing diversity, equity, and inclusion internally and perhaps also programmatically. Okay, so that's sort of our beginning section that's setting the stage. Now I want to run through the anatomy of bylaws and some drafting tips. So this is our sort of top to bottom tour of the bylaws. So we'll start at the top. Article 1 of our template bylaws is establishing the corporate name. So, I mean, this is pretty straightforward, but consistency is key. Make sure that the name in your bylaws is identical to what's in your articles and your government filings. If they don't match, corrective amendments are going to be necessary in one or both or all of those documents to have a consistent name throughout that is consistent with the name that you're using in the real world. Okay, so that was number one. That's an easy one. Your mission and your purpose statement. So this is something that surprises some people. Our recommended approach is to just have the bylaws cross-reference the mission or purpose statement that's in the articles. This goes back to consistency. Cross-referencing it instead of restating the mission or purposes makes sure that your bylaws and your articles are completely in line. If you do prefer to restate your mission or purposes in the bylaws, just make sure that it's an identical statement to what's in your articles. Otherwise, you're going to have a conflict. Your articles are going to control, but there could be conflicts or confusion or inconsistency at your organization. If there are inconsistencies, amend one or both to conform with each other, and then also check what you're putting in your 990s under that mission description field that you file every year. This is a template purpose statement from our template articles of incorporation. You'll see we break down the purpose statement into two sections: a specific charitable purpose that you can sort of craft that's really specific to what your nonprofit does and what its mission is. And then in B, we have a sort of catch-all statement. So the purpose statement reads, our nonprofit is organized to, feed the homeless and to engage in any other religious, charitable, scientific, or educational purposes, blah, 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 blah. So that's our structure. We like this. Our tip is still, even with the specific purpose statement, is to keep it as general as possible to accommodate a variety of activities and also to include the catch-all provision. By doing this, it gives you the flexibility, there's one of our key words, to pivot when it comes to your programs, your activities, your constituents, your target population, your geographic region is something that people limit themselves in sometimes. By removing those kind of limitations and keeping it relatively general, you can make those pivots and changes without having to amend your articles and bylaws. Note that amending your articles will require you to provide a notice to the IRS on your Form 990, and it'll also require a filing with DCRA, the district government, or whichever government regulator oversees the corporate documents for your nonprofit. Okay, so section 3 is about your corporate offices and your registered agent. So this is one of those sections that's going back to that legal compliance theme. In DC, a nonprofit needs to have a corporate office address to obtain a basic business license. And all nonprofits that take in more than $25,000 in revenue in a year require a basic business license. So that office provision sort of restates that requirement, right? We will have an office. The registered agent requirement is also kind of echoing another DC government requirement. Nonprofits in DC and most other jurisdictions are required to designate a registered agent and to keep that information up to date with DCRA. So section 3.02 just says we will have a registered agent. But notice how these bylaws are affirming the legal requirements, but also trying to ensure maximum flexibility. So the offices provision says that we'll have an office. It can be within or without the District of Columbia. So it can be anywhere, and we can maintain additional offices as required. And with a registered agent, it says we'll have a registered agent, but of course the board may change that person from time to time. So we're always trying to balance that compliance piece with that flexibility piece and carving out flexibility for the organization whenever we can. Article 4, it's about members. So in our template bylaws, you'll see it's for a non-membership organization. The corporation shall not have any members. I really hate this term members because that word, it has so many meanings in so many different contexts, including in the nonprofit world. What we're talking about here is kind of a narrow definition of the term members. It relates to your governance and your corporate structure. Nonprofits can take two forms. They can be membership organizations or non-membership organizations. In a membership organization, the members are like stockholders in a for-profit corporation. They elect the directors and sometimes also the officers, and they approve major corporate transactions like corporate mergers. So they are a body of people with specific rights and obligations vis-a-vis the nonprofit organization. In a non-membership organization, we do not have that separate body of quote unquote members, and all of these core corporate decisions and the election of directors is all occurring within the board itself. So it's a board only kind of structure. Having members is optional. Generally, running a membership organization is more complex and administratively demanding. Non-membership nonprofits, i.e. those governed only by the board, are much more common today. And another reason that I think non-membership nonprofits are more common is because a lot of the goals that we have when we have a membership nonprofit, like including our stakeholders in the decision-making process, having people invested in the nonprofit outside of the board who feel like they're having some role to play in the governance process, that's something we can still do via committee structures and via other sort of ways that we can engage our constituents. So it's not necessary to have a membership nonprofit to still engage the people who you want to be quote unquote members of your organization. Anyways, so your articles are going to have the final say on whether you're a membership or a non-membership organization. Check your articles to make sure there should be a clear article in your articles of incorporation saying we are not a membership organization or we are a membership organization. Depending on which form the organization takes, the bylaws will vary significantly. So for membership organizations, special considerations will include how you determine membership, how you hold the mandatory annual meeting, that's a legal requirement, and also special meetings, how you determine who is a member with respect to a specific meeting, so you can decide who gets to vote at that meeting. It'll have notice requirements, it'll have procedures for calling and holding special meetings, as I mentioned. It'll also have voting requirements for the members when they vote, and it'll also address the issue of director and officer elections because it's the members who are going to be electing those individuals most of the time. Today's presentation will not focus on membership organizations because they're relatively uncommon, and most of you listening are going to be in a non-membership organization, but I will sort of throw out some member-specific considerations as they come up. But just note that the template bylaws that we're looking at today and the conversation that we're having is really focused on a non-membership nonprofit. Okay, so the next section, and it's the big section, is about the board of directors. And the first thing that your bylaws are going to address is membership on the board. It's going to set the number of directors. DC law requires a minimum of 3 directors on the board. Bylaws will typically express a higher acceptable range for the size of the board, e.g. it'll say the nonprofit will have between 3 to 9 directors or between 3 to 13. Even if your aspiration for the size of your board is higher, set a safe kind of lower bound in case one day, 10 of your directors up and walk out of the organization, you still want to be able to have a functioning board to kind of rebuild afterwards. So again, that flexibility piece there. That minimum of 3 is low. There's a lot of risks and issues if you only have a 3-director board. If anyone has a conflict of interest, it might make it very hard to make decisions. Also, everyone has to show up to have valid meetings. So we do, in practice, want you to have a larger board than 3, but you can still set 3 as a lower range if you'd like to. So the qualifications of a director. Only individuals, i.e. like human persons, can serve as a director. You cannot have an XYZ organization on your board, although you can give an organization the right to appoint such an individual if you so choose. That's pretty unusual. Usually, all the directors on a nonprofit board are elected onto the board. I want to note here that directors do not have to be a resident of DC or even the United States to serve on your nonprofit board. That issue of ex officio members. So you can choose to have ex officio directors on your board. It's not common, but it's possible. Ex officio directors are automatically members of the board because of their position or office. A common ex officio member might be that the CEO/executive director is automatically a member of your board, or maybe the immediate past president is always a member of the board. A confusion that some people have is that ex officio members are automatically non-voting members. That's not true. Ex officio members almost always have the right to vote unless your bylaws specifically say that they don't. And it's not a good idea to have non-voting members on your board because they have the sort of same legal liability as voting members, but they don't actually have the authority to affect how the organization votes and to make actual decisions. So it puts them in a really awkward spot. So we don't recommend having non-voting members that are nevertheless directors on the board. Okay, so some other director-related issues. Term lengths, or the period of a term. Bylaws should specify a director's term in office. If they're silent on this issue, the DC default is 1 year. It is better to have multi-year terms, and it's better to have terms that are staggered between what we call classes of directors, so that a completely new board is not elected each year. So that if there is sort of periodic turnover as people's terms expire, that doesn't happen all at once. Maybe you have 2, 3, 4 classes of people cycling off the board every year. Okay, and then there's also the issue of term limits. So your bylaw may contain term limits, which will put a cap on the number of terms a director can serve, either permanently or what you'll see is a cooling off period, like they have to be off the board for 2 years before they can be reelected. It's considered a best practice to have term limits because that ensures that the board's membership is refreshed instead of being entrenched or stagnant. So you have new individuals coming onto the board, it forces you to have sort of new ideas and new perspectives coming onto the board in a regular manner. It also prevents the board from kind of getting too cozy and complacent with the management of the nonprofit. So you have sort of new critical perspectives coming onto the board as well. The big issue with term limits, though, is that if you have them, make sure to follow them. Some of the kind of naughtiest issues I've had to untangle are nonprofits who have had term limits but have not been holding regular elections. The board is fine, everyone likes each other. They didn't want to go through the work of electing new people, so they just served for like 10 years. And then some kind of conflict arises or some sort of issue arises, and now we have disputes about who was validly on the board and what to do about the decisions that directors made while they had overstayed their stated term. It's a huge mess, so we want to make sure that we abide by our term limits if we have them. Okay. Also, we should address the procedures for removing directors or for the resigning of directors. In a non-membership organization, directors may remove a fellow director with or without cause unless your bylaws say otherwise. It is possible to have for cause removal, but we really don't recommend it because that can generate some legal disputes and delays surrounding whether or not there was adequate quote-unquote cause to remove a director. The kind of more straightforward approach is just to let the board vote. If they vote to remove a director, they're gone. And that can sound maybe risky or dangerous or mean or potentially sensitive, but this is one of those completeness issues. We have to plan for the worst case scenario. If we have a director that we really need to be off the board for whatever reason, maybe they're disruptive, maybe they're potentially committing crimes, we want them off the board today. So we want the ability to do that and to not have fights or a lack of clarity about their status. Same thing with resignations. Allow directors to resign on demand. If they want to resign, they just write in saying that they're going to resign. They say the date they're going to resign, then they're gone. Don't put in burdensome requirements that the organization has to accept the resignation or they have to provide a certain amount of notice. It's the same idea. If someone wants to be off the board, they might have a really good reason, and we want them to be able to be off the board. That attendance requirement that I mentioned. So consider including a provision that if a director misses a particular number of meetings in a row or over the course of the year, that person is automatically off the board. Again, that can save you the awkwardness of removing non-attending directors, and it communicates your attendance expectations up front. Attendance at meetings is such an important issue for nonprofits. Non-attending directors can affect your ability to get quorum, and they themselves are going to have a hard time exercising their duty of care and duty of loyalty to the organization because they're not getting the information that they need to be informed and active board members. You don't want those kinds of individuals hanging on to your board. So some organizations choose to put in an automatic removal requirement in their bylaws based on attendance. And then another issue is vacancies. So you should definitely allow remaining directors to fill a board vacancy by a majority of vote whenever one arises. Vacancies on the board, same issue, right? If your board is too small, it can't do the work it's supposed to do. And you can also have situations where you have so few board members that you have a hard time reaching a quorum or getting the numbers that you need to pass a majority vote. So your vacancies clause should also address what happens if there's only one director left on the board. Everyone else is gone. Then what do we do? In our template bylaws, our vacancies clause says that in that situation, the sole remaining director can sort of elect new members onto the board. Checking for questions. Okay, great. Okay, so that's sort of your board membership. I kind of want to shift to the procedural requirements that you'll see in your bylaws. So the bylaws should provide for regular board meetings. These are meetings that happen on a regular schedule. You can set the date itself in the bylaws. So it'll say we have a meeting third Monday of every month, but it's better to have the board adopt a resolution at the beginning of the year, scheduling its regular meetings for the rest of the year. If you do it this way, you don't have to provide separate notice for each of the regularly scheduled meetings. The bylaws can also schedule or require to be scheduled an annual meeting to elect new directors and perform other periodic tasks. I just want to note that I'm seeing all of your questions coming in. If I'm not addressing them right away, it's because we're probably going to get to them later on in the presentation. So hang tight. Special meetings. So the board is also able to call special meetings. These are meetings that are not in the regular meeting schedule. The bylaws should specify who can call a special meeting and how much notice is required. If you're silent on those issues, the DC law default is that the chair, the CEO, or 20% of the full board can come together to call a special meeting, and they require 2 days notice. Your bylaws about that notice part should specify the form that notices should take. Older bylaws will say you can provide notice by mail or by like personal service or something. Make sure that your bylaws are updated, allowing the provision of notice through email or other electronic forms, because that's what we're all practically doing nowadays. Someone's asking what's the difference between annual and regular meetings. Annual meetings typically just have a special agenda that's attached to that annual meeting. So, so definitely electing your directors is something that you want to put on that agenda. By putting it in the annual meeting, you're just sort of guaranteeing that that agenda item gets addressed at least once a year. So that at your annual meeting, you might also want to do your annual conflict of interest disclosure forms. That's another sort of annual requirement that boards need to do. So there's nothing that has to be in your annual meeting, but just as a best practice, it's a good place to put those critical agenda items to make sure that they get done every year. Okay. More on meeting procedures, electronic meetings. So by default, as we mentioned, electronic meetings by telephone or web conference are allowed. So the kind of homework point here is to make sure that your bylaws do not contain language specifically barring electronic meetings. For clarity, if your bylaws are silent, consider adding language that specifically permits electronic meetings so that everyone knows that they're appropriate and available going forward. Board voting. Okay, so by default, the board should be able to approve actions by a vote of the majority of directors present at a meeting at which quorum is present. You get to set what level quorum is at your organization, By default, it's a majority of the directors currently in office. You could bring it down to like a third of the directors in office, but that's not recommended. I mean, if you think about like a 9-person board, do you really want 3 people on a 9-person board being able to make kind of binding final decisions on behalf of the entire organization? Probably not a situation that we want. Acting by unanimous written consent. This is another option that DC law allows. It allows the board to act via unanimous written consent unless your bylaws say otherwise. So check your bylaws, see if there's language specifically prohibiting or allowing unanimous written consent. It's a really useful option for those kind of routine or non-controversial matters. What this means is that, we'll go back. What this means is that if you have an action like and you send out a written resolution, and then you have a 7-person board, all 7 people write in affirmatively agreeing to that action, then the action passes and you don't have to have a meeting to approve the action. As we'll talk about later, either voting during a meeting or acting unanimous written consent are your 2 options for making binding board decisions in DC. There's nothing in between. So check your bylaws, make sure that they can do unanimous written consent. And then I had a note about Robert's rules, and this has actually come up in the questions already. In a regular nonprofit board, there's no need to observe complex procedural requirements like Robert's rules. Even people who say that they're using Robert's rules are not actually using Robert's rules. Robert's rules are over 600 pages long. They change all the time. If there is some external reason for you to be observing Robert's rules, go ahead and do it. Like maybe you're kind of more of a legislative or kind of parliamentary style structure at your nonprofit, and it makes sense to observe Robert's rules, then sure, include that in your bylaws, then as sort of like an appendix to your bylaws, attach Robert's rules. But in sort of 99.99% of nonprofits, there is no reason to abide by Robert's rules. There's certainly no legal requirement, and it can cause more trouble than it's worth. The board has to learn the rules, which takes forever, and then you get all these conflicts about whether you're following the rules properly or not. A lot of people do the thing where they kind of first and second a motion. That's great, you can keep doing that. It doesn't mean that you have to do all the other Robert's rules. Someone is asking to clarify, can you have something less than unanimous written consent, like 2/3 written consent? No, you cannot, and we'll get into it. Okay. So this is, well, I have unanimous written consent twice. Okay, here, let's go back to it then. DC law, so again, it allows you to act by unanimous written consent. That means 7 out of 7, must agree. You cannot vote by proxy or by ballot. So what do I mean? By proxy, I mean you're a director and you ask another individual to vote on your behalf without you being personally present at a meeting. Not allowed. Voting by ballot, that's voting remotely outside the confines of a meeting, so by writing, via email, etc., without a unanimous written consent requirement. Cannot do it. All right? A lot of bylaws, relatively, especially older ones, do allow for proxy or ballot voting, but a 2010 nonprofit code amendment to DC law clarified that these practices are not permitted. So, you discuss a matter at a meeting, some people are at the meeting, and then a day later, someone sends out, a doodle poll or an email saying, can you vote yay or nay on the thing that we discussed at the meeting? Not allowed, because that's not a unanimous requirement. So it can't pass under our unanimous written consent rule, and it's not within the confines of a meeting. And that can be an in-person or electronic meeting, but this vote is not within the confines of the meeting. It's not limited to those who are present at the meeting. So voting rule either. So it can be kind of complicated to think about. The clearest way that I recommend people thinking about it is to think that you only have 2 options: unanimous written consent or a vote at a meeting. Everything else, every like hybrid or other structure, not allowed. It kind of goes back to that idea of fiduciary duties. So part of your duty of care as a nonprofit director is to participate in meetings, it's to be engaged, it's to share information, it's to listen to dissenting views. If we're doing that without an actual meeting, then only unanimous written consent is acceptable, because that kind of thing is so uncontroversial. I guess we didn't need the meeting in the first place. But everything else, we want the meeting to occur for the vote to be valid. And now with modern electronic technology, we can call an electronic meeting very quickly, or it's very easy to vote by email consent. So those 2 options are not hyper limited. they do give you a lot of leeway to act quickly if necessary. Okay, so the next section that our bylaws will address are your corporate officers. The bylaws must provide for what officers you have and how you'll select them. Let's first talk about the legal requirements in this area. DC law doesn't specify a number of officers or a specific title for your officers, but they do require nonprofits to have three kind of functional officers. One is a chief management officer, the second is a chief financial officer, and the third is someone responsible for maintaining the books and records of the organization. Again, these are functional roles. They don't have to be the literal title for each of the person fulfilling these roles. How this usually breaks out is the chief management officer is often the most senior staff person at your nonprofit, so that's your executive director or your CEO. For all volunteer organizations that don't want to hire staff or that don't have the money to hire staff, the board president or board chair, who's a volunteer, generally also serves as the chief management officer. Okay, so your chief financial officer. In smaller organizations, the chief financial officer is usually the treasurer. As organizations get larger and more sophisticated, you can kind of delegate that off to being a paid staff position. Maybe you're chief operating officer, or you have a chief financial officer, or you have a vice president of finance. But in a lot of organizations, the CFO is the treasurer. And then the person responsible for maintaining your books and records, that is generally fulfilled by the board secretary. Again, in very large, sophisticated organizations, you might be able to transfer that role to a staff person. But the kind of homework piece, the takeaway, is to make sure that your bylaws specify which of your officers are meant to fulfill each of these legally required positions. So if you can't answer the question of who's the CMO, who's the CFO, and who's the books and records person at your nonprofit, you need to go back and clarify that. Okay, but let's look at how nonprofits actually structure these officers in practice. So most nonprofits have in their bylaws a core set of board officers. These are usually the chair, vice chair, treasurer, and secretary. So the chair oversees the board and presides over meetings of the board. The vice chair performs these functions in the absence of the chair. The chair and vice chair are always directors because their duties are so intimately connected with the board itself. Some organizations choose not to have a vice chair, that's fine. The kind of logic around having a vice chair is that it helps with succession planning. You sort of have someone there to kind of train up and learn the functions of the chair, making it easier for someone to step into that position if the time comes. The treasurer and the secretary, on the other hand, have duties that are specific to the whole organization and not just the board. So that's finance and corporate record keeping, respectively. These positions, as we mentioned, can be filled by staff persons. However, the more common practice is to also reserve these positions specifically for board members because it helps with succession planning, again, and it also enables the board to meet in executive section. That's like a meeting of the board where only directors are present and still have all the officers in the room. If you have a staff officer, that person can't participate in the director-only executive session, and that might cause some issues. The bylaws should outline the duties of each board officer and the process for electing them. You should require a majority vote of all directors for your officer appointments. So this is one of the few cases where just a majority vote at a meeting at which a quorum is present is not enough or should not be enough to appoint an officer, because you really want the full board, quote unquote, on board with the decision to select an officer of the organization. Okay, so those are your corporate officers. Now we have another class of officers that we call administrative officers. These are individuals who are generally executive level, that is paid staff, rather than volunteer directors on your board. Your bylaws should allow the board to create administrative officers as needed, because that gives you maximum flexibility. But you could also specify some standing administrative officer positions. And the most common standing administrative officer position that we see spelled out in the bylaws is your CEO or executive director. Recall that they also typically serve the function of the chief management officer for DC legal purposes. In our template bylaws, our practice is to have the bylaws create that standing position, but only require that the board fill it when it has the funds and the abilities to hire a candidate. Until the organization hires a CEO ED, the chief management officer position is performed by the president or the chair. A note that your CEO ED is always considered an officer under DC law and IRS rules, whether you call them an officer or not, unless they do not exercise the actual authority of the CEO or ED. Other common administrative officers might include your C-level executives like your chief financial officer or your chief operating officer. But it's important to note that not everyone with kind of a fancy title is automatically an officer. Someone can have a title like vice president of programs or director of communications and not be an officer. The line here is that an officer has the authority to perform certain activities on behalf of the nonprofit as a whole, such as signing government filings on behalf of the nonprofit. That's the big one. Executing deeds and other contracts, opening bank accounts. They can speak for the whole organization, and that's a power that other employees do not have. Officers also have enhanced fiduciary duties while serving in their capacity. So they have kind of those legally recognized and enforceable duties to act at a certain standard of conduct. So it's a more serious commitment in that way. So the takeaway is that it's very important for the board to clarify which of your staff executives are quote unquote officers versus other high-level staff. Okay, so we'll turn away from individuals now and move to committees. Committees are a huge part of your bylaws. Under the DC code, a board can establish two types of committees, board committees and advisory committees. There are no requirements that you have any committees. It's all permissive, so this is up to your organization. Board committees have the authority to make decisions on behalf of the board. For example, if the board appoints a finance committee, that committee can make binding changes to the budget the same way that the full board can. So common board committees that you see are an executive committee, but also your audit, compensation, strategic planning, development, public relations, and governance nominations committees could all be board committees. There are a few exceptions to what committees can do. A board committee cannot elect or replace the directors, amend the bylaws, dispose of a substantial portion of your nonprofit's assets, or in membership organizations, recommend that a matter be put forward to the members for a vote. A little bit more on board committees. Because board committees have such broad powers and final authority, only directors can serve on a board committee under DC law. This is something else that I see nonprofits struggle with in the real world. They have created committees, they haven't formally decided if it's a quote unquote board committee or not, and they're putting their staff members or outside experts or other people as voting members of those committees. Not allowed because board committees are essentially an extension of the board itself. Membership on a board committee is limited only to directors. Also, the creation of the committee and the appointment of individual members onto the committee have to be approved by a majority of all directors, not just a majority of directors present at a particular meeting. Again, the logic here is that because we're delegating board authority to another designated body, we want the full board to participate in that decision and to approve that decision. Again, no committees are required under the DC code, and as a matter of bylaws drafting, your bylaws can simply empower the board to create committees as needed, and then leave the specifics to be laid out in a sort of committee charter for each committee. And that is the approach that our template bylaws take. We don't specify any required committees. We just give the board the power to create committees on demand. One common exception to that is the executive committee, which typically has general authority over all board matters rather than only in a specific issue area. Executive committees are typically used to facilitate decision-making between board meetings or in a crisis situation where you can't get the full board together for a kind of quorum qualified meeting. Because executive committees can seriously affect the balance of power and decision-making process at your nonprofit, bylaws are often specific about whether they are allowed or disallowed within an organization. Your organization, your board might come together and have a sort of targeted strategic conversation about whether you want an executive committee on your nonprofit or not. It's kind of a divisive issue. We have a separate webinar about executive committees on our website, and I'll give you a link to the website at the end. We actually have separate webinars about 90% of everything I'm talking about in today's presentation. So if you have follow-up questions, that would be the first place to start. So the bylaws can also authorize the board to create advisory committees. That's the other option. These committees can make recommendations to the board, but they don't have final authority to make final board level decisions. Some committees that I see as advisory committees are maybe a fundraising committee, Your PR or communications committee can be advisory. Organizations are adopting junior boards as a kind of board development tool. That's usually an advisory committee without final board authority. Advisory committees can also make staff level decisions that don't require direct board approval or oversight. So for example, you can have an events committee that plans and executes the annual fundraiser for the organization. Non-board members can serve on advisory committees. It's actually a great opportunity to engage non-directors in the governance and leadership of your organization. So again, as a drafting matter, your bylaws should just be flexible, allow you to create advisory committees as needed. There are also other kinds of committees. There are sort of ad hoc committees, or there are task forces. These are sort of more time limited or issue limited committees that might pop up from time to time. As long as your bylaws generally empower the board to create committees, you can also spin off these more limited committees as well as you need. Again, all about flexibility. Okay. So now this is a section that's in our template bylaws. I get a lot of questions about it. We have a big long section about indemnification. And the reason is because under DC law, if an officer or director is sued with respect to their conduct in service of the organization, and they ultimately prevail in that lawsuit on the merits or otherwise, that director or officer is legally entitled to indemnification from the nonprofit, i.e., your nonprofit must cover the legal fees and other costs related to the proceeding. That's one way that DC law protects, directors and officers of a nonprofit. And actually, a lot of organizations go further. In order to recruit and retain, good officers and directors, nonprofits often choose to expand that indemnification protection. For example, they might offer to front the costs from the beginning of a lawsuit instead of waiting to see if the officer or director prevails at the end. And nonprofits, for this reason, typically purchase directors and officers liability insurance, D&O insurance, to fund those indemnification obligations. So your articles should be specific about whether and when the organization will offer the expanded indemnification. Again, that more limited indemnification is mandatory, but you can choose to offer expanded indemnification. And then the bylaws should have a section describing the process that the board will use to approve indemnification decisions on a case-by-case basis. So when a lawsuit comes in, the board should get together and say, yes, we will indemnify the director who's being sued. We will hire a lawyer and cover those expenses through our D&O insurance for this matter. There should be special attention to ensuring that that process is free from conflicts of interest. So at a most basic level, the director who's trying to seek indemnification should not be part of the group that's deciding whether to approve the indemnification or not. We also have a section on 501c3 compliance in our template bylaws. This basically restates some kind of basic compliance requirements that you will not, be operated for the private interests of individuals, that you will transfer your assets to another C3 when you dissolve or terminate. Your articles should have this language as well. The idea of putting this language in the bylaws is just to restate a commitment to complying with these requirements. This might fall under our sort of culture values theme that we talked about first. It just sort of ingrains a culture of compliance at your nonprofit. So it's optional, but we have it in our template. There should be a section establishing the fiscal year of the nonprofit. The fiscal year is something that you shouldn't mess around with too much. So you can use a calendar year, or you can go on a different kind of cycle depending on your revenue grant program and audit related considerations. A lot of organizations do not operate on a calendar year, fiscal year. But the note here is that changes to your fiscal year do require IRS notification, either by filing a 990 for the kind of short year that results after a change, or if you've made a change in the last 10 years, you actually have to file a separate form. So putting this in your bylaws kind of ingrains it a little bit more, and just have in the back of your head that if that's something you amend, it has a filing requirement attached. Another section that we have is this execution of documents provision. I get a lot of questions about that. It's pretty straightforward. It just guarantees that if a person has more than one office, so if they're both the secretary and the treasurer, they're not signing contracts or other documents twice, once as the treasurer and once as the secretary. So as a person can only sign under one capacity. And then there's also a check signing provision that we recommend being in there. It specifies which of the officers has check signing authority. So in our template, it's either the CEO, the treasurer, or the chair. Something you might want to think about spitting out is requiring 2 signatures on some, i.e. very large, or even all of your checks as an internal financial control. So that's a conversation to have at your organization if that's something that you want to put in the bylaws themselves. Another thing that's not in our template bylaws, but that you might want to think about including is that DC law prohibits nonprofits from making loans to their officers or directors. So to kind of, again, to kind of make that compliance requirement very transparent and very clear, you might want to create a provision in your bylaws saying the nonprofit shall not provide loans to officers or directors. There are some very narrow exceptions to that rule, but that's the general rule. Okay, we're nearing the end. Amendments. So this is the last provision in our template bylaws. It's just a provision that says that the board can have the power to amend the bylaws. Note here that we require a 2/3. So this is one of the supermajority requirements, and that it's 10 days notice. So that's a longer notice requirement that we require for our typical meetings, which are usually 2 days. So you should have something in your bylaws to this effect to make it clear to everyone that there's an amendment process. This is where I'll make a note about membership organizations. The amendment process is much more complicated in membership organizations, and some amendments do require membership approval. Cool. So that's our sort of tour of the bylaws. I just want to close out by mentioning a few things. First is this process of kind of living and reviewing your bylaws. So you should definitely review your bylaws on a periodic basis. Going back to that consistency theme, we want to make sure that they're consistent with the real world practice at your organization, and that they're continuing to be, relevant and supportive of maybe shifting organizational needs and practices. So reviewing your bylaws could be a project of the full board that you do at a designated time. Alternatively, you might have a governance committee, or you might create an ad hoc bylaws committee that you delegate the primary responsibility of conducting the review and recommending amendments. Maybe you want to put your lawyers and your more sort of policy-minded folks on the committee to do that first cut. A best practice is to perform a review at least every 2 to 3 years. You'll see people say a longer period, like 5 years or something like that. But 2 to 3 years is kind of what I'm recommending. But also, you should conduct a review in response to big changes at your organization, either internally or sort of programmatically, or if there are changes to the law that affect nonprofits. So as I hinted, back in 2010, there were significant changes to the DC nonprofit code, and every nonprofit in DC should have revised their bylaws following the implementation of those changes. If you haven't, you're definitely a priority case for going back and doing kind of a big redraft or review of your bylaws. We should also include a review of the bylaws as part of your orientation and onboarding process for directors and for staff. Finally, I want to go beyond the bylaws. That's what today's presentation is focused on, but I want to end by noting that your bylaws should not be your only day-to-day governance document. Nonprofits should be adopting policies and procedures as needed that are relevant to their operations and businesses. And the IRS actually has some strong recommendations in this area via the governance questions that they ask on the 990. Based on those questions, we recommend that all nonprofits have a conflict of interest policy, a whistleblower policy, and a record retention policy. And as I mentioned on our webinar archive and our resource library, we have information about all 3 of these policies. So you can check out that stuff after. But then beyond those IRS recommended policies, other common policies might be a code of ethics for the organization, a board manual or board guidelines, a compensation policy. Setting the compensation of the CEO is such a core function of the board and a unique function of the board. A lot of nonprofits create a policy around how they do that. If there are specific risks in your organization, especially organizations that work with children, you might want to have a child safety policy about how you handle those risks. Anti-harassment and non-discrimination policies are always a good idea. On the finance side, a gift policy about how you accept gifts, and an investment policy about how you invest your money. And then something new that's sort of popping up is a social media policy around how your organization is represented in social media, who has control of social media accounts, issues like that. So that's it. And we are kind of a little over the hour, so apologies for not being able to get to everyone's questions at this time. I am hoping that a lot of the questions were eventually addressed in the presentation. But again, if you have specific questions that you weren't able to get in today, please, my email address is here, jqu@dcbar.org. Send them over to me and we can chat offline. And then I want to point out the 2 links on this slide. The first is to our general nonprofit resource library. And then again, for the folks, especially for the folks listening in after the fact, you can download our template bylaws at the website, probono.center/template bylaws. So thank you again, everyone, for joining today and for listening in. Enjoy the rest of your day and best of luck with your bylaws revisions. All right, bye everyone.